Hello, my name is Jason Rhodes, and I am a patent attorney at BSKB. Recently, the Federal Circuit discussed the potentially limiting effect of preambles in its holding of Pacing Technologies versus Garmin, decided on February 18, 2015. In this case, the plaintiff, Pacing Technologies, owned a patent for a system that paces users during activities which involve repeated motions, such as running, cycling, or swimming. Pacing Technologies asserted this patent against Garmin, who sold GPS fitness watches and microcomputers to runners and bikers. Garmin also ran a website which allowed users to design and transfer a workout to these devices. Each workout consisted of a series of intervals, and each interval was assigned a duration and target pace. During the workout, Garmin's devices would display each interval by counting down the time for a particular pace, while also displaying the user's actual pace. This case hinged on whether or not the asserted patent claim required the system to pace the user by outputting a tempo, for example, an audible beat or flashing lights. Garmin's devices did not do this. The preamble of the claim recited a repetitive motion pacing system for pacing a user. At trial, the district court held that the preamble was a claim limitation and construed it to mean a system that outputs a tempo. Based on this construction, the district court granted summary judgment to Garmin, and Pacing Technologies appealed to the Federal Circuit. The Federal Circuit agreed with the district court that the claim preamble indeed referred to a system that outputs a tempo to the user, due to a clear and unmistakable disclaimer in the patent, in the form of statements characterizing the objects of the invention. The remaining question was whether the preamble was a claim limitation. The Federal Circuit noted that preamble language is generally not treated as a limitation when it merely states the purpose or intended use of the invention. However, the court then referred to one of its previous holdings, Eaton Corporation versus Rockwell International Corporation, in which it found a preamble to be limiting because other limitations in the body of the claim relied upon and derived antecedent basis from it. In this case, the Federal Circuit went one step further, finding that the preamble of the asserted claim, an independent claim, was limiting in part because it provided the antecedent basis for a limitation in one of its dependent claims. As such, the Federal Circuit found the preamble to be a limitation of both claims, thus holding that the claimed invention requires a tempo to be outputted. Since Garmin's devices did not do this, summary judgment for Garmin was affirmed. In conclusion, it now appears that courts can construe a preamble to be a limitation of a claim by virtue of providing antecedent basis to a limitation in a dependent claim. Keep in mind, however, that the issue of whether a preamble limits a claim is fact-specific and decided on a case-by-case basis. Thanks for joining me, and I hope you learned something today. Stay tuned to bskb.com for more upcoming videos of interesting cases and other commentary on intellectual property.